Welcome to today's program, The Nuts and Bolts of Arbitration, Consumer Arbitration. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Adam Shoneck and Delton Henderson. Delton is an accomplished attorney, arbitrator, and mediator licensed in California and New York with more than 20 years of experience advising clients across business, entertainment, and nonprofit sectors. He serves on the national roster of American Arbitration Association and FINRA. Adam is Vice President of Business Development and Outreach at the American Arbitration Association, where he oversees the organization's consumer case administration teams across the eastern United States. With nearly 16 years of experience at AAA, he has held multiple leadership roles focused on operations, business development, and client engagement. We can't wait to hear what they have to share with us today, so I'm going to turn it over to them.
Thank you so much. Again, my name is Adam Shoneck from American Arbitration Association, and we're here today to talk about the nuts and bolts of consumer arbitration. So I'm going to go ahead and share my slides. All right. So we'll talk about what is the AAA, just some basic background information. We'll talk about the stages of the consumer arbitration process, AI best practices, and then we'll talk a little bit about our consumer arbitration data that we publish. So what is the AAA? We're a 501c3 not-for-profit organization. Our headquarters are in New York, but we have footprint across the U.S. with a number of offices. Dozens, I believe, and locations abroad as well. We were founded in 1926, so just 1 year after the Federal Arbitration Act, and we are coming up on our centennial celebration, so look out for that starting next year. And we are the largest provider of arbitration services in the world. When it comes to consumer cases, we are by far the largest provider of services, consumer services in the world, based on our number of cases that we see. So when you talk about consumer arbitration, it's very important to talk about fairness and transparency as well, because the consumers are not electing arbitration. The businesses are electing arbitration for them in these contracts. And so because the consumer, by our definition, didn't have any negotiating power or any say in how these contracts were written, these contracts have to meet a minimum due process standard. And that's embodied in the Consumer Due Process Protocol, which was developed in the late 90s by AAA in conjunction with advocates for businesses and consumers and consumer interest groups to make sure that any contract for consumer arbitration we received must meet those standards contained in the protocol. And if they don't, then we won't administer the case. Now, we will ask the business to waive that provision or provisions of the contract that do not comply with the protocol. But if they don't do that, then we will decline the case. Paired with that is our consumer clause registry. So in our rules, we ask that if a business is going to name us in their agreement, they first send us a copy of the contract, probably terms of service or standard purchase agreements, that sort of thing that consumers would sign, subscription agreements, that sort of thing. They have to send it to us first to make sure that it does comply with our Consumer Due Process Protocol. If it doesn't, we will not register it, and we will ask for changes in the agreement or a waiver of the provisions before we'll go ahead and register that on the clause registry. The registry is open to the public, and it's part of our mission to be transparent and to educate everyone involved in consumer arbitration about the types of clauses and that sort of thing that are out there. I mentioned our consumer arbitration rules. These are a special rule set just for consumer arbitration cases. We just updated these rules this year, so they're brand new. That's a whole separate topic we could talk about, but the process that we're going to talk about today follows the consumer arbitration rules process. These were designed with the protocol in mind, of course, to maintain the fairness standards of the protocol in consumer arbitration. So, stages of the process. First, a case is filed. Cases can be filed on our website, adr.org. There's a big red file a case button in the top that a party can go to, and it'll take them through the steps of the filing process. That's the simplest way to file. Parties can also file by email or mail, with email being the increasingly more popular choice there, as you can imagine. There's a couple things that a filing party, we call the filing party the claimant, that they need to file. So one is the demand for arbitration. We have forms on the website. We have one specific for consumer that they can use, or they can just provide a written statement that has all the information we're requesting from the demand, which is basically a brief description of the dispute, how much is involved, the names and addresses, contact info for the parties and their representatives, and some other administrative data that we need to get the case going. The other thing we need with the filing is a copy of the contract that names the American Arbitration Association. So before we can administer a case, the contract has to name us, or the parties have to agree to bring their dispute to us. So we need that with the filing as well to make sure we have jurisdiction to handle the case. Once those things are filed with us, the claimant needs to serve the other party, who we call the respondent in the case. And that will start the ball rolling. If there are any deficiencies in the filing, we will reach out to the parties to say, hey, we need X, Y, or Z. But otherwise, we'll move on from that stage to the initiation stage, which is where we request the answer. But I want to turn to Delton for a minute to talk about some best practices for the filing a case stage.
Okay, well, thank you very much, Adam. Again, my name is Delton Henderson. I am and have been serving as a consumer arbitrator for the AAA for 6 years, I think maybe going on 7 years. One of the highlights, I think, of being a part of such a organization and program is this document that Adam referenced, the Consumer Due Process Protocol. For me, it's not just a set of requirements that you kind of check off. It's a statement of values. The protocol says, in effect, that the arbitrator should be, or arbitration should be, accessible to the party despite cost, or their preparedness and familiarity with the process, and attempts to strike a balance between, that, unique, distinct space that consumer arbitration occupies in the ADR field. So again, when I'm presented with a case, the initial documents, the demand for arbitration and the answer, what I'm looking for as an arbitrator is a sort of clear not sort, but a clear and concise statement, description of the dispute. It doesn't have to follow the traditional pleading formalities, and oftentimes it will not. And if you're dealing with a circumstance where the claimant is unrepresented, but it should provide enough detail to allow me to understand and appreciate, what is being asked, and what support, is available to get us to the resolution of the dispute at hand. In terms of things that I would recommend not doing, when preparing either a demand or a response to a demand, is being overly sensational. I know that sometimes in a litigation context, or maybe as a result of one's proclivity towards creative writing, attorneys will do a lot of things, gymnastics of a sort, in terms of language. That typically is less helpful in the initial stage of the process, because again, my goal is to be able to understand and appreciate, why the parties are there. And if I have to weed through these additional adjectives and adverbs, to get at the essence or the substance of the claims and potential defenses, then it just makes the process a little less efficient. Other recommendations or things that I would suggest avoiding is not preparing, before you submit, your documents. I've had instances where, for example, it's a two-tiered conflict. There is a contract on top of a contract, each with a separate arbitration provision. And as a result of this case being presented, for arbitration, we must consider the context of both of these agreements. One may state a preference, a governance law of, state of California, and the other may make the, governing law some other state. This is obviously presents a preliminary issue that has to be resolved. If counsel or if the parties are aware of this in the beginning, this is something that we could certainly address sooner rather than later, maybe even in advance of scheduling our preliminary hearing. So I would, caution you to check the agreements or documents, before, for things like jurisdiction, and, if there are any conditions that are required, before this process could be engaged. Certainly do that.
Thank you, Delton.
Sure.
And so we mentioned the answer that comes after all the filing requirements have been met, and we'll request that from the respondent. Typically, under the consumer rules, a respondent has 14 days to provide their answer after the demand was filed. We don't adhere to formal pleading requirements in the rules, so these do not have to be that formal. We recognize, 14 days is part of the expedited nature of arbitration, in allowing for shorter statements to move the process along. Once the answer is filed, or if no answer is filed, we take it as a general denial. But we will then go ahead and appoint the arbitrator to the case. So the arbitrator is, like Delton, the person who decides the case, and they will govern the case and how it moves, which stages you go through, and the schedule of the case and whatnot. So they will really manage the case along with the AAA after their appointment. In a consumer case, arbitrators are appointed by the AAA. We have a specialized panel of consumer arbitrators, more than 1,700 or so across the country, who hear these cases and who are experienced in hearing these cases. We'll explore the data a little bit later, but we have about 8,500 cases a year or more. So that gives you an idea of how many cases we get versus how many arbitrators we have. So we will appoint an arbitrator, and part of this is for efficiency's sake, but part of this is also to maintain fairness in the process. We know that the business will tend to see more cases than an individual consumer, and therefore a business, if provided with a list process, would be able to have additional information about the arbitrators from their prior cases that the consumer might not have. And so we decided, okay, we will just go ahead and appoint the arbitrator so there's no influence on how that arbitrator is selected. If there is an issue, a party can object to the arbitrator. And by issue, I mean the arbitrator has to make copious disclosures when appointed by the AAA, including information about past cases and whether they've worked with one of the attorneys in representing one of the parties, or have been involved with either of the parties before, along with a host of other information. So there is that disclosure period where the parties can review those disclosures and go ahead and make any objection to the arbitrator based on that information. The AAA then decides whether to keep the arbitrator or remove them, and that decision is final. We go from there. And so once the arbitrator is appointed, we'll go ahead and schedule the preliminary hearing. So this is where the parties and the arbitrator get together and talk about the schedule for the case. What kind of discovery is needed? When should motions be submitted? Is this going to be a desk or a live hearing? Any requirements for the award that the arbitrator needs to know about? As Delton mentioned earlier, any issues like governing law or other things that are going to be sticking points for the case. So it's usually an hour or less, and the result of the preliminary hearing is a scheduling order, which is issued to the parties. And again, that sets out the scheduling of the case. So Delton, when you are running a preliminary hearing, what do you tell parties that they should do or not do?
Well, thank you for that. I chuckled a bit there when you mentioned the length of time that a preliminary hearing traditionally should take, because I was of the mind, and certainly the practice, to try to keep it to 30 minutes. Which
that works
doesn't
too.
usually,
yeah.
It doesn't usually work out that way. But, I think what really helps in preparing for and then managing the preliminary hearing stage of the process is the parties' preparation for this stage. It is perhaps one of the most important procedural moments in the case. This is when we're going to explore, the extent of discovery that may be desired or requested by, the participants. We will discuss, the type of hearing that will, be used for, the process, and a host of other, sort of preliminary issues would be addressed during this process. So I think one of the keys in terms of determining time and being inclined more towards efficiency and economy is the request of parties to prepare in advance. I think that would be the overwhelming tip that I could offer, and at this stage of the process. I typically approach the preliminary hearing with 5 objectives. I wrote them out so that I could remember to articulate each of them for you. The first would, involve making sure that the participants understand this process. As we mentioned, my background in commercial mediation, I learned that you recognize when parties, regardless of their resources or sophistication, might not fully understand what the process is and what options are available to them. Consumer arbitration presents a very similar dynamic. The parties are, if unfamiliar with arbitration procedures, may feel uncertain about, certain requests, or, apprehensive in, providing information that is essential for, getting the process going. So I start there, and secondly, I try to help them help me understand what the key issues are, if that hasn't already, been established in the preceding submissions, the demand and the answer. The third focus would be to discover the discovery protocol. This is something that we'll discuss maybe a little bit in greater detail later, but that's important. And a realistic schedule. How much time is really going to be required? How many, witnesses, if any? Will there be expert, testimony or reports submitted? All of these things would, if we're prepared, we would, address and try to plan them out accordingly. And then finally, the fifth thing is to address, any threshold issues, dispositive motions for whatever they, may stand for. So that's my general approach to the preliminary hearing, and tips that I would offer to practitioners or participants in the process.
Thank you. And so one of the things we've mentioned a couple times is whether there's going to be a desk or a live hearing. So a desk hearing, by default under the consumer rules, anything under $25,000 will be a desk hearing. And this is where each party submits their position via brief, and the arbitrator reviews the brief and issues an award. So this is generally for smaller cases, again, under 25,000 in the consumer rules. And there's no live evidentiary hearing at that point. So it's just on the documents. We do have live hearings. If a party requests one and the arbitrator finds that a live hearing is necessary, even for a case under 25,000, we will then have a live hearing. The default is virtual, although the arbitrator can decide, no, we're going to do this in person. And a live hearing, again, could be virtual. It could be telephonic. It could be hybrid, where some of the participants are in person and some are not. Or it can be in person. So the in-person hearings since COVID are less and less these days. It's somewhere around 80% of cases have a virtual hearing if they have a hearing. So that gives you an idea of that was even before the rule change that made the default all virtual hearings. So obviously, live hearings is going to be a longer process. There's additional administrative fees that are associated with having a live hearing for us to set it up and whatnot. And Delton, what are your thoughts on when each of these might be useful for parties?
Well, so the desk arbitration, which, as you described, includes a decision based on the documents only, I think tends to be most appropriate where credibility is not an issue, or the necessity for expert testimony and demonstration is not necessary. Clearly, if it's a contract-based claim and it can be sufficiently presented in documents, I find that the desk arbitration is more helpful. We'll get to, I think, this topic a little bit later as well, but certainly with the onset and the availability of artificial intelligence now, it can provide an assist in that area as well to make the process even more useful, perhaps. Keeping in mind that the goal, the primary goal is to provide the parties with a fair process, that achieves economy and efficiency. Certainly, the AI tools might be useful, in a desk arbitration context. Live hearings are certainly, more appropriate when live testimony and like I said, I think demonstrations and credibility, is an issue. And I find that those are less and less, as you mentioned, live because of the ease of being able to present a case, through the virtual platform, and more importantly, is the cost, of having, to secure, a facility and have witnesses show up and the like. It's more, probably less common, that we're doing live arbitrations anymore. Or we're doing them live, but we're not doing them in person, but virtually if they're live.
Got it. Yeah, we found it's much more convenient for parties to do the virtual hearings rather than having to, take off work and go travel somewhere to be at the in-person hearing. So yeah, desk arbitrations have some expedited deadlines. So the award is due within 14 days from when the parties submit everything, versus in a live hearing where the award is due 30 days after everything is submitted, just to make the process a little more streamlined in desk cases. We'll move on to motion practice. So one of the misconceptions that a new practitioner might bring into arbitration is to treat it just like court motion practice. We have some stricter guidelines in the rules as far as when motions can be filed, including dispositive motions, because the idea is really to get to the hearing and have the issues heard expeditiously, get an expeditious award. So you're already uh, briefing a lot of the same issues that might be in the dispositive motion for the hearing. The arbitrator may decide to hear that issue at the hearing in order to save time and make it more efficient. And under the new consumer rules, before considering a dispositive motion, the arbitrator has to consider the cost of briefing that motion. Delton, what are your thoughts? If parties are going to submit motions, how do you like to receive them? How should they be written? What are your best practices there?
Well, so since we are in arbitration, not in court, and I'm not a judge, but an arbitrator, I personally prefer clarity over formality. And I wouldn't be more inclined to entertain a motion if it's short, focused, and grounded in contractual language, which is very different, I think, than what a motion would look like, or what it might contain if it were being presented to, a judge in the federal courts. Here in arbitration, the underlying relationship filter is the contract to the extent that one exists, and or the assumption of the existence of a contract, through practice. So that would be, extremely important to me when reviewing a motion request. And I know that we've had some offline discussions about this, and I think that with the traditional comparison of arbitration and litigation, and the fact that many who come to arbitration have a litigation background, the expectation is that the counsel will have that level of expectation or opportunity. So I like well, I don't like to do this, but I have to do it in the beginning. I typically remind them that motions are not a matter of right. You have to convince the panel that they would help streamline the process and get us to that end goal in a way that is economical and efficient. And I probably would say those words, many, many, many times. But I think those are, important goals to have. And so that's kind of how I would respond to a motion request. And
Okay. Obviously, motions often relate to evidence and discovery, so we'll talk about that stage next. Obviously, these can be intertwined depending on how your scheduling order is written, but in the evidence discovery stage, so the idea with arbitration is that it's not full discovery like you would get in court, but an important distinction with consumer arbitration is that it still has to be a fair process. And so the arbitrator has broad authority to require the discovery that is appropriate for the case, keeping in mind the efficiency of arbitration. So where that falls on the continuum, it's not commercial arbitration, which is very little, if any, discovery, but it's not anywhere near full discovery that you might see in litigation, unless, of course, for some reason that was really required in the arbitrator's discretion for a full hearing. Arbitrators are allowed to order depositions take place, interrogatories. So the full range of discovery tools is generally available in consumer arbitration. Just the volume of them would likely be less. Delton, what are your thoughts on best practices in this stage of the process?
So here I would rely on the concept of proportionality. Uh, Consumer arbitration cases typically involve dollar amounts that are modest. That is in no way to say that all of these the cases that I handle are small cases, but I think a large number of these disputes can, range somewhere between hundreds of, thousands, maybe tens of thousands of dollars. There are categories of cases that I handle that will be millions. And obviously in those cases, you should expect a more robust discovery process. So proportionality, I think, is really key. Keeping in mind, that it shouldn't cost more to put on the case than what the case itself is worth. So I don't know if that's
Sure. The rules do call for exchanging documents early, so there is some bit of asking the parties to work together so there hopefully aren't any discovery issues, but at least the exhibits that they intend to rely on and any witnesses that they intend to bring to the hearing have to be disclosed as well. And so if you are going to have a live hearing, we used to say that consumer arbitrations generally don't exceed 1 day of hearing. We don't say quite that anymore because there are some that do need more than 1 day of hearing, but generally it's going to be a half a day of hearing or less for a consumer arbitration. Delton maybe can correct me if I'm wrong on that as far as the timing of the hearing, but there's no it's not you don't have to call the arbitrator your honor, and it's not necessarily a set procedure, although we'll generally follow typical court procedures. There may be an opening statement from each side, there may be a closing statement from each side depending on the case, but generally this is not a long process. People may testify by video, they may testify by affidavit instead in order to streamline the hearing process. We can use videotape depositions as witness testimony if the parties are okay with that and agree, or the arbitrator orders it. So it can be very flexible. Like I said earlier, it can be hybrid. So the arbitrator really has authority to fashion that hearing in a way that suits the case. Dalton, what are your thoughts as far as best practices for hearings?
Yeah, I think what is really quite unique in the consumer arbitration cases that I have facilitated is that it's largely a panel made of one, just me, doing everything. And unlike, in a courtroom where a judge may have, bailiffs to take care of the room and a clerk to hand, evidence and to manage all the process, it's one person doing all of this. So I do typically insist on a formality of sorts, and it can be construed as rigorous, but I like to say firm but flexible.
Okay.
But typically, what's important for me, in that context is, and this, of course, would vary because if I'm on a panel, which happens more frequently in my commercial arbitration cases than it does in the consumers, or now, for example, I'm on a panel for an appeal for a consumer case, then the division of labor can make the process a little bit more flexible and accommodating, to what the needs are of the parties. But so back to the mainframe experience I'm usually the only person handling all of this. It is an active management process. There is the introduction or admission of evidence. There is the objections to that evidence. We typically follow the rule that evidence is admissible in the procedure process so long as it's reasonable and material. And as all the lawyers in this webinar will appreciate, those terms aren't so easily defined, and there's so many varying degrees of interpretation of what that means. So you can end up spending an awful lot of time, just deciding what you're going to and what you're not going to allow to be presented. So I definitely try to structure that part of the live hearing in a way that makes it more manageable, and maybe even less stressful, for people. Presentation of evidence, through testimony or through other forms, that I think you're right. It tends to be a less rigorous, less formal, less more in personal, or maybe not quite personal. I wouldn't go that far to say that, but that's what I would say about the live hearing process. There wasn't something else I wanted to add, but it escaped my mind. Maybe I'll come back to it later.
Sure. So after your hearing, the arbitrator may ask for post-hearing briefs. They may not. So sometimes it depends on the case. Sometimes it depends on the arbitrator, whether they like post-hearing briefs or not. But at some point, the arbitrator will decide that they have all the information they need to close the hearing. And so once the hearings are closed, that's a formal process for the AAA. There's no more evidence or anything else that gets submitted to the arbitrator, nothing else for their consideration, because this is the time when the award clock starts to run. Some arbitrators will, especially in consumer cases that have attorney's fees, if the consumer wins the case, they may bifurcate the award, and they may decide to do an interim award that decides liability. And then if the consumer wins or the attorney's fee provision is triggered, then take briefing from the parties on the issue like attorney's fees and decide that issue separately. And the thought there is that arbitrators can save the parties time and money in not briefing that before liability is decided, because obviously if it goes the other way, then there's no need for the attorney's fee award in those cases. So we see that a lot in consumer cases, that there may be an interim award deciding liability, and then a final award is what we call it, that decides the attorney's fees. But if there's not an interim award, then everything is just in the final award itself. The default under our rules is that the award has to contain the brief reasons for the award, which means it's not full findings of fact and conclusions of law like you might see in an employment arbitration case, but it is not as simple as so and so wins or so and so loses. It has to contain the reasons why the award was decided the way that it was. Part of this is awards are published, as I think I mentioned earlier. And another part of this is that in consumer arbitration, you really want to know the reasons why so that the consumer can understand that it was a fair process, that it was deliberately thought out, and even if they didn't win the case, that they can at least see why they did not win the case. As I mentioned earlier, if you had a desk arbitration, the deadline for that award is 14 days from when the hearing is closed. Otherwise, it's a 30-day deadline from when the hearing was closed. And Delton, I want to ask you about the scope of award and maybe some things that an arbitrator should keep in mind as far as the authority that they bring to the table as the arbitrator.
Well, for those who are less familiar with arbitration awards, I would just posit that, unlike a judge's ruling, which could be appealed for any number of reasons, the arbitrator's final award can only be challenged on limited grounds. If it's, being administered under the FAA, the Federal Arbitration Act, then, there, I think, are a list of 10 conditions or circumstances that would permit, one to a right to, have a review of the award. And California Arbitration Act has a very similar. For me, I think that the most important aspect of the award writing is that it's to think of it more as something more than a legal analysis, because what I want to achieve is an understanding by the parties of what they need to hear about how I reached the decision I reached and why. And so obviously I tend to write longer awards, and I don't know why, but that's what I do. And the reason for doing so is just that I want them to understand the process, that a decision was not just reached out of a vacuum, but a real thought was given to, all of the evidence that had been presented. Weight was accorded to, every component that was, available to me as the panel, to consider as it relates to the issue. So I tend to take a little bit more time, in drafting those than I think is customary. In more complex cases, I mean, obviously, within the context of consumer arbitration, it's not really fair to say that there are, complex and non-complex cases, because these are cases that involve people with, lived experience that they are trying to address through a process that has been imposed upon them in many, instances. And therefore, you want to, again, err on the side of, building or establishing a balance, the equity component of it, the decision-making process is something that's very important to me. And I did make a couple of things. So I did make a note for myself that in terms of what I would like to accomplish in drafting an award. And I'll share that with you if you don't mind. I initially would begin with what I called a concise statement of the dispute, and the relief that the parties were seeking, and whatever relevant factors, that I was able to extract as undisputed facts versus those that were in fact disputed, materially disputed, and then lay out what that legal standard is. I mean, it's very similar to what we might have done, as law students in creating briefs, but I'm adding, I think, what I would call a human element to it, not to the extent that it's shifting my position as a neutral, but to the extent that it's providing, some support, that would make the audience, the recipient of that information and communication, more receptive to accept it, even if it's not in their favor. And oftentimes that's, the case. The people who are, who don't win or get what they want are at least happy with the way that you reach your decision. So I'm aware of that, as much as I'm aware of the very narrow, circumstances in which an award can be overturned. And of course, you would want your award overturned. So that's something to keep in mind. I wanted to achieve a sense of clarity as well, and conciseness, brevity. I had a professor in law school who always preached brevity, and it's like, what does that mean? We're writing legal documents, and the more words, the better, right? It's usually not the case, and especially when drafting an award. So that's usually the approach that I would take: calculated, methodical progress towards the end result.
Thank you, Delton. And that was a nice covering of the post award, and that these are final and binding decisions, subject to very limited circumstances for appeals, modification, and vacator. It's interesting. You mentioned you're serving on a consumer appeals case. Appeals are not common in arbitration. They only occur when the party's agreement calls for an appeal, but the consumer space seems to be the most popular space for those kind of appeals provisions in contracts. So just an interesting tidbit there. But I want to shift gears, move away from talking about the stages of the case to talking about AI use in arbitration. The AAA is using AI for a lot of different things. We partnered with ClearBrief to offer that services to arbitrators, and that allows them to make timelines based on the submissions, check citations, and generally perform their document review function much quicker and better. We've published a number of AI case preparation books. So a party can go to this AI book, and it was written by human authors, but we took AI, then you can ask questions about the book, and it'll give you answers based on the book. We have rules chatbots, excuse me, for each of our rule sets as well, including the consumer rules, and a chatbot that helps parties get through the filing process. Our online portal has AI document summarization. We use AI in our arbitrator searches so we can get the most expert arbitrator for your case. And we tried a number of different things, some of which didn't work. For example, we tried an AI scheduling order tool where the AI would take the transcript of the preliminary hearing and spit out a scheduling order that was okay, but needed more work than was really uh, saved in that process. Um, and Delton, what are your thoughts on AI uses and best practices?
Again, I'm a strong proponent for use of AI as a tool, and I've now include a provision in my scheduling orders, that basically invite the parties to, incorporate it as a tool, in the process. I had during law school, I had a nickname, I guess that my fellow classmates had given to me. It was Data. But I could remember the page numbers that certain cases were on, and if there was a holding or a ruling stated specifically, I could tell you which paragraph in that page it was. I don't know why, but that was sort of how my brain operates. And so it can be, overwhelming, when you're trying to cipher through so much information. And having a tool like, oh, I won't say any brands, but I mean, having access to tools that would, help, streamline that process, of sifting through the information and creating, charts, it's extremely, important. I had, for example, a recent arbitration, which again, I think stands as an exception. This was 5 days, full days of testimony. Each side had 4 or 5 experts, and it was extremely detailed, very technical issue. And at the end of it, I had learned so much more about this particular, operation, but at the same time, I was, I was not an engineer, so it was helpful to be able to have the tools like ClearBrief, which the AAA provides, complementary to its arbitrators, to put my data into this program and then tell it to organize it for me so that I could find things more easily. And in this case, I also requested for the AI to create hyperlinks to each of the cases and statutes that were cited within the documents that I was reviewing. So because this is a closed universe, it's only the information that I'm feeding it. I wasn't as concerned with, some of the challenges that people are having with generative AI. So these hyperlinks would enable me to read the document and have, let's say the case, in a separate panel, and be able to go back and forwards between the case and the brief, at the same time. And it would even do, citation checks and offer, history of that case, and it just was, quite robust. It could never have, would have never have been able to imagine handling all of that information by myself, for and meeting a 30-day deadline to draft an award. I mean, so that I'm a strong proponent of, the use of AI, to get back to your question, when it's used appropriately and ethically. I think ethically is important as well.
Thank you. We only have a minute left, but I did want to show some data about our consumer arbitration caseload. So this is for 2024, and in early 2026, we'll come out with our 2025 numbers. But we had about 8,500-ish consumer cases filed last year. That was down a little bit from 2023, where we had about 10,000. Most of those cases were in California, about 3,000 of those. Texas was the next state with over 700. Most of those cases settled, 55% settled. About 13% were awarded. So that gives you an idea of the sort of breakdown between how these cases get disposed of. And we saw the most cases in financial services. So that includes consumers against banks, consumers against crypto exchanges. That crypto exchanges really drove a lot of these cases last year. And I think it's important to highlight, that these cases were resolved by award in a median of 8.5 months. The settled cases obviously may have resolved a lot quicker than that. And consumers didn't pay fees in more than half of these cases. So we either waived fees or the business was responsible per the contract in more than half of the cases we received last year. I think that's the end of the program, but I'm happy to share my email address if anyone has other questions. It is shoneck@adr.org.
And mine is Delton, Delton, at lawofficedrh.com. And thank you all for attending.
Thank you. This concludes today's presentation. Thank you so much, Adam and Delton, for your time and sharing your educating our members today. And thank you so much to our members for attending. Have a great day, everybody.